The initial consult in advising the value of prenuptial agreements is very important. That's where you're going to, as you can see here in the outline, you need to understand their objectives and their concerns. You need to find out, how does the client want to live and what is their lifestyle going to be after they get married? Everyone has a different concept of not only marriage, but how they want to establish their marriage, how they want to establish their finances. Will it be joint? Will it be separate? If you don't understand exactly what that client wants, if you don't understand what their lifestyle is going to be like, then the prenup will be completely impractical. If it's impractical, if the parties are not able to live by it, that is a way to invalidate a prenup, which we will get into later in the presentation. So that's why it's important in the very initial consultation to understand what their objectives and what their concerns are, and definitely what their lifestyle is. Will they be able to keep their assets separate, as a prenup may indicate? Will they be able to understand it? Will they be able to understand what the provisions say so that they can actually live it? Now, you also need to figure out what their fears and concerns are. Some clients will come to you and say, I fear that he's going to take all my inheritance at the end of the marriage, or at some point during the marriage. Some clients will come to you and say, I fear she's going to take all of my retirement that I've worked hard for the past 15 years prior to us getting married. Those are things that you're going to have to deal with in the prenuptial agreement. You're going to have to spell out in detail what they have, what they entered the marriage with, and how they're going to deal with it upon divorce. Again, we'll talk more about, later on in the presentation, asset schedules, liabilities, income, all of that. But just for right now, talking about the initial consult and what you need to understand. You really need to pay attention to their fears and their concerns, where they're coming from and where they're going to in the next chapter of their life. You also need to look at if there are any current judgments or orders that would affect client authority over their property or income. And by this, I mean, oftentimes, and at this point, we have about a 50 to 60% divorce rate. And most of those people, according to the statistics, are getting remarried. So you're going to have to look at least half of your clients that come to you for a prenuptial agreement have likely already been married before. So you need to make sure you're going to understand what their judgment already says. For instance, if their judgment, their prior divorce judgment, has provided for a life insurance policy or a college savings plan, for example, you will likely not be able to change or convert those assets in any way because a current existing judgment is there defining that property and has authority over that property. Those clients that come to you with those kinds of judgments are going to need to understand that they cannot change that judgment because of the prenup. They can change the judgment in a different fashion, in a modification action, for example, but the prenuptial agreement is not going to change those existing judgments. The prenuptial agreement also cannot convert those assets into joint property with the new spouse if the existing judgment has authority over those particular assets. Again, the most common time that's going to happen is going to be a life insurance policy, a college savings plan, for example. But it will also likely affect your client's income. For instance, oftentimes in existing divorce judgments, you will have provisions for child support and alimony, or one or the other. Oftentimes when someone has a base compensation, a base salary, and then they have a bonus on top of that, the bonus structure is going to be provided for in such a way as to oftentimes give a percentage of the bonus to the ex-spouse, either for child support or for alimony. As you understand that about their existing divorce judgment and you're looking to create a prenuptial agreement for them, which oftentimes will have provisions for alimony for that next spouse, you want to make sure you're not going to double dip. So for instance, you need to set out in the prenuptial agreement that the bonus income that that particular person has is going to be separate property. because you don't want to have a situation where the ex-spouse is receiving the bonus as part of the prior judgment, but you also don't want to have the potential future ex-spouse also be able to dip into that bonus income, because then your client is going to be suffering the consequences of two people trying to get at the same income. So you need to understand that there's existing judgments. You need to understand how that will affect the client in the future if they do get a divorce. That would mean you're going to have to add into the asset schedule, again, which we'll get into later, add into the asset schedule the bonus structure, the income, the compensation package, and literally define how it's going to work out, how it's going to play out, and reference the prior judgment. Now, you'll also see here in the outline that prenuptial agreements can also be part of an estate plan. So in your first initial consultation, you need to talk to your client about whether they have an existing estate plan, and if they do, make sure the prenuptial agreement is not going to be inconsistent with that estate plan. If they don't, talk to them about how they may want to establish an estate plan. We're not going to go into estate planning here, but that's certainly a concern that you need to cover with your clients. You also might talk with them about any trusts that they may have, trusts that they have currently, or maybe that they would like to get into, whether it's in their marriage or they already know that one is going to be established. That will also need to be handled as part of the estate plan and provided for in the prenuptial agreement. You also need to confer with your client at the initial consultation about what happens without the prenuptial agreement. Every state has a different law, as you know, about how to divide assets, calculating alimony, and calculating child support. So we're not going to get into the variations of the law in terms of what may happen, but you do need to let your client understand what would happen if they have a short-term marriage, a mid-term marriage, a long-term marriage, and if they get a divorce at any point during their marriage, and how the law in that particular state would play out for them, how it would leave them at the end of a marriage if it ever did dissolve. If they don't understand how that would play out, later on when we get into valid waivers of their rights, they're not going to be able to sign the document. They're not going to be able to understand what they waived. They're not going to be able to understand their position. And if you ever did get in a situation where the prenuptial agreement had to be enforced, it may be invalidated, especially if that client is going to be on a stand at some point at a divorce trial and say that he or she never understood their rights in that particular state and what may happen if they never signed the prenuptial agreement. So you definitely need to make sure you're educating your clients about the situation they may be in during the marriage and upon divorce without the prenuptial agreement.